the Honorable Chief Minister of Tamil Nadu, Thiru M.K. Stalin, Thiru Kiran Rijiju, the Union Minister of Law and Justice, my distinguished colleagues, Justice V. Ram Subramaniam, Justice M.M. Sundaresh, Honorable Justice T. Raja, the Acting Chief Justice of the Madras High Court, Justice R. Mahadevan, Judge of the High Court of Madras, and all the colleague judges of the High Court, Thiru P. Murthy, the Honorable Minister of Commercial Taxes, Registration and Stamp Law, Dr. Palanivel Tyagarajan, the Honorable Minister of Finance, Thiru S. Raghupati, the Honorable Minister of Law, Thiru R. Shanmugasundaram, Advocate General of Tamil Nadu, all the
Vandarai Val Vaikumnad. The state of Tamil Nadu has truly lived up to its reputation. Thank you again for the warm, gracious, and heartfelt hospitality. Last year, the then Chief Justice of India visited Chennai for laying the foundation stone for a 9-story administrative block at the Madras High Court. Less than a year later, the state has another project on its card to augment court infrastructure. Tamil Nadu is truly leading the way in boosting the infrastructure of the court system. I have been frequently speaking about the deplorable infrastructure of various courts across the country where litigants, lawyers, and judges do not have access to basic facilities such as a clean washroom and a resting space. The courtrooms are cramped with no ventilation. The justice system is choked with the huge pendency rates, and so are the judges and lawyers inside a non-ventilated court hall. In most district courts in the country, there are no sanitary napkin dispensers for women lawyers. In many district courts in the country, there are no washrooms for lawyers and for lady judges, women judges. Studies have shown that a comfortable working environment enhances the work output. I hope that the administration consults all stakeholders and caters to their spatial requirements before commencing the construction of the building. When the former Chief Justice of India visited Chennai a year ago, Thiru M.K. Stalin put forth 3 points for consideration. The first was for the setting up of regional benches, which the Honorable Chief Minister again referred to a short while ago. The second for introducing Tamil as the official language in the High Court. And the third, ensuring inclusivity as a principal factor in making recommendations for the appointment of judges. I would like to use this stage to speak to you about all the endeavors of the Office of the Chief Justice of India in addressing these 3 concerns. I have been striving to ensure access to the Supreme Court for lawyers and law students who do not reside in Delhi. I always say that the Supreme Court of India is not the Supreme Court of Tilak Marg, but it is the Supreme Court of the entire nation. We have introduced a hybrid system by which lawyers can appear before the Supreme Court both physically and virtually. This facility enables the seamless connection between a judge sitting at Tilak Marg in Delhi and an advocate residing in Melur or Virudhunagar. Additionally, we have started live streaming all constitution bench cases. This provides students from government law colleges in Madurai or Trichy the opportunity to watch Supreme Court proceedings and to be educated about, and an advocate residing in Melur or Virudhunagar. Additionally, we have started live streaming all constitution bench cases. This provides students from government law colleges in Madurai or Trichy the opportunity to watch Supreme Court proceedings and to be educated about the way the law is. I must share with you certain facts which may otherwise not be known. During the course of the COVID-19 pandemic, 2.62 crore cases were heard by the high courts and the district judiciary on video conferencing. 78 lakhs in the high courts and 1.84 cases in the district judiciary. The Supreme Court from 23rd March 2020 till 13th February 2023 heard 4,13,537 cases through video conferencing. The use of this modern technology has enabled us to reach out to our citizens. Lawyers in the Supreme Court who appear before us are unquestionably the leaders of the profession in Delhi, but equally the base of the pyramid in the legal profession comes from lawyers from socially and economically marginalized backgrounds. The tip of the iceberg is very small. The base is what defines the identity of the legal profession. The clients are in day-to-day touch with lawyers from the district judiciary. When a second appeal comes to the High Court, the client in the districts is in direct touch with the arguing advocate in the High Court or through the intermediary of the High Court who has conducted, the lawyer who has conducted the first appeal. Opening up the facilities of the Supreme Court to lawyers not merely from the centers where the High Courts are situated, such as Chennai, but lawyers from all over the country, from the districts, would enable a reduction of the cost, because the lawyer in the district judiciary charge a fraction of what is charged by a lawyer in the high echelons of the system. But there is a great deal of confidence which the citizen has in the lawyer who has conducted the case in the forum where the case was instituted. So our effort in the Supreme Court is to use technology to truly make ours as a national court where we can hear the voices of our citizens through lawyers who have an intimate connection with their lives, who know the social conditions in which these social problems which are brought before the court emanate. With respect to the second point of enabling the use of Tamil as an official language in the High Court, perhaps a constitutional amendment would be necessitated having due regard to the provisions of Article 348 of the Constitution. I am cognizant of the language barrier and the ensuing impact of this barrier on opportunities to young graduates. English is not our first language. We think and formulate our thoughts in our mother tongues. However, I implore all young lawyers who are facing some difficulty with communication in English not to be demotivated. I request the judges of the Madras High Court to be encouraging towards the young juniors and not let language barriers impede effective representation. I was Chief Justice of the Allahabad High Court for a period of nearly 3 years. A young lawyer would open the case by saying, "May it please your lordships," the old colonial form. But the English advocacy very often ended with saying that. The rest of it was conducted in the mother tongue of the lawyer. I belong to Mumbai, and my knowledge of Hindi was deeply influenced by Marathi, my mother tongue. But I found that speaking to the lawyers in their mother tongue brought me in very close connect with the members of the bar. They did not ridicule me for the errors which I would sometimes make in expressing myself in their mother tongue. But they appreciated the fact that a genuine effort was being made to connect with lawyers so as to make them comfortable in the language of discourse in the courts. Because when litigants and lawyers are comfortable with the language of the discourse, they can present their viewpoints fearlessly and effectively. So we as judges must encourage the youngsters at the bar and help them build confidence in communication. In an attempt to localize the justice delivery system and bring it closer to the citizens, we have started translating judgments of the Supreme Court in other official languages recognized by the Indian Constitution, including Tamil, with the aid of artificial intelligence. I hope that this initiative will go a long way in not only bringing the court closer to the citizens, but would also help lawyers who are not conversant with the English language to keep up with the developments in law. Since independence, there are 34,586 judgments of the Supreme Court, all written in English. Our judgments were being made available to our citizens by private law publishers for whom you had to pay a subscription of between 30 to 50,000 rupees a year. How many young lawyers in the districts or in the taluka courts can afford a subscription of this nature? So one of the first steps that I took after I took charge as Chief Justice of India on 9th November last year was to digitize all the 34,000 plus judgments of the Supreme Court. These judgments are now available free of charge, not merely to our citizens, but globally to anybody who wants to read the judgments of the Supreme Court. We have also ensured that there is a free text search engine which can be accessed by citizens across India. But we have not stopped at that. The IIT Madras has provided to us an AI-based software for translating of our judgments, but translation of judgments through artificial intelligence requires human verification. So we have requested all high courts to constitute a team of retired district judges who will verify the correctness of the translation. And the Supreme Court is using its own funds to ensure that the translations are put out. Today we have 4,428 judgments which have been translated. The project is in its infancy. To give you an idea, 4 have been translated in Assamese, 1 in Garo, 3 in Gujarati, 4,243 in Hindi, 17 in Kannada, 1 in Khasi, 29 in Malayalam, 14 in Marathi, 3 in Nepali, 26 in Odia, 4 in Punjabi, 52 in Tamil, 28 in Telugu and 3 in Urdu. The reason I gave you these statistics is that I request now the government of Tamil Nadu to take this up as a mission. And I'm sure that with its commitment towards infrastructure, this is a joint mission for all of us to reach out to our citizens. But it is not just the judgments of the Supreme Court which have to be translated. All the judgments of the high courts must equally be translated into every regional language available in India. The judgment search portal of the E-Committee of the Supreme Court has 1,11,06,805 judgments of the high courts, all available free of charge. Out of these 1,11,00,000 judgments which are available in English, 8,76,000 judgments are from the state of Tamil Nadu, from the Madras High Court. I would request the Chief Justice of the Madras High Court to take up the translation of these 8,76,000 judgments of the Madras High Court which are in English into Tamil, so that not only the judgments of the Supreme Court are made available to the citizens, but equally all these 8,76,000 judgments are available to lawyers and citizens across Tamil Nadu, as well as the representatives of this great state who reside across the world to know of their rights. Moreover, the judgments of the High Court, when they are translated into Tamil, would be made available to police stations, to education officers, to collectors, to tehsildars, So revenue judgments will be made available to the revenue arm of the state. Judgments on criminal procedure will be available to the police academies, to the police officers. Judgments on education would be available to the education department. So look at the potential which we have today in terms of technology and a little bit of imagination if we apply it. I hope, therefore, that this initiative will bring us closer to our citizens. On the third point, which the Honorable Chief Minister justifiably made, that is inclusion as a principal factor for the appointment of judges, in the earlier collegium recommendations published by my 6-member collegium that I head, we have laid out the factors for consideration. And these factors for consideration include representation to members of the marginalized communities, including women and the backward communities, and to the best extent possible, representation to all the high courts. Because the Supreme Court, to my mind, is truly a Supreme Court which represents the nation. And we are making a conscious effort to ensure that different high courts, different regions of the nation, find representation in the Supreme Court. I next turn to the lawyer community assembled here. But before that, I must share a small anecdote. When we started live streaming of our court proceedings, a distinguished member of our bar, who is also a member of Parliament, Mr. P. Wilson, interacted with me. He's a member of the Parliamentary Standing Committee attached to the Department of Justice, which visited the Supreme Court last year and again 2 days back to interact with us on legal aid schemes. And the learned member of Parliament shared with me that by allowing hybrid hearings, hearing lawyers from across the country, you are truly becoming a court for the nation. So that a lawyer sitting in Chennai, or for that matter anywhere in the state of Tamil Nadu, or from Orissa or West Bengal or Kerala or Maharashtra or Madhya Pradesh or UP can address us as judges of the Supreme Court. Now I turn to the lawyers community. I like to highlight 3 issues. First, there is a need to enhance the entry-level pay for junior lawyers. I am told that the entry-level pay in Madurai for young law graduates is somewhere between rupees 5,000 to rupees 12,000 per month. Such poor pay disproportionately impacts members of the marginalized communities, such as the scheduled castes and the scheduled tribes, and women. The impact of this, or the impact of which, is that it takes the form of an entry-level barrier and forces young graduates to take up other work unrelated to their branch of study just to make ends meet. The law does not become a primary profession for young entrants because they don't make enough money in their chambers. The usual defense by recruiting chambers for such low pay is that the first few years of a young associate's career is a learning stage where the senior mentors them. I would request the senior members of the bar, please shed this paternalistic approach. Today's youngsters are sharp, hardworking, and hungry for work. Interact with them about their approach towards the law. I have 5 judicial clerks, all of them first-time lawyers with no connection in the legal profession in their families. One of them, a woman lawyer, is from Madurai. She comes from an agricultural family. But the benefit of women's education in the state of Tamil Nadu, she went to a national law school and now has come to work with a judge of the Supreme Court. Another sister has become a doctor and has gone abroad to pursue higher education. So that shows you the power of women's education. You will be spellbound by the fresh approach that young lawyers bring to the table. All I ask of senior lawyers is to trust the youngsters of the bar. with work and fairly compensate them for their hard work and long hours. The old approach where young lawyers just came to us to learn has to be replaced by an understanding that they contribute as much as they learn. As a judge of the Supreme Court, I learned so much from these young law students and lawyers who intern with me, who clerk with me, coming as I did from different parts of the country with no legal background, but with a tremendous source of optimism and dedication for hard work. The second issue that I want to highlight is the abysmal men to women ratio in the legal profession. Statistics inform us that for 50,000 male enrollments in Tamil Nadu, there are only 5,000 female enrollments. The legal profession is not an equal opportunity provider for women, and the statistics are the same all over the country. The face is changing. In the recent recruitments to the district judiciary, over 50% are women. But we have to create equal opportunities for women so that women do not fall by the wayside because of the fact that they undertake multiple responsibilities as they progress in life. Chambers are skeptical about recruiting young women advocates. The reason for it is not a lack of young talented women. There is no lack of talented young women, but rather because of our actions being a product of the stereotypes that we hold against women. There are two prominent stereotypes against women that translate to denying women opportunities, and forgive me for speaking about them. Firstly, recruiting chambers assume that women would be unable to put in long hours at work because of familial responsibilities. We should all firstly understand that childbearing and childcare is a choice, and women should not be punished for taking up that responsibility if they wish to, but rather encouraged and supported in any choices that they may choose to